Let's welcome back criminal defense attorney Eric Schwartzreich. Great to have you back with us, Eric. And just wanted to get your assessment. When we talked to you a couple days ago, it seemed as though you felt like the defense had done an adequate job, at least, of presenting the case on behalf of Ms. Clancy as if she were not criminally responsible. How do you see the jury coming down?
So it's a tough case, right? Let's not lose sight of the fact that 3 children were murdered individually, where the father was sent out of the house with exercise bans. And jurors don't like sanity defenses or criminal responsibility defenses here in the Commonwealth of Massachusetts. However, in this jurisdiction, it is what's called the McCowell standard. Different in other jurisdictions, which typically follow the McNaughton standard, which is just whether or not someone appreciates the consequences of their actions. And that burden is on the defense here in this jurisdiction, in the Commonwealth of Massachusetts. The government, the Commonwealth, has to prove beyond a reasonable doubt that she did not suffer from a medical disease or defect. They've conceded that part. But the issue for the Commonwealth here and their burden of proof beyond a reasonable doubt, the highest burden of proof in the criminal court system beyond a reasonable doubt, is to show that she didn't appreciate the consequences of her actions and couldn't conform her conduct. The defense here has done a masterful job with the evidence and poking holes, and Reddington has also, created reasonable doubt, even though that's not his burden. What I didn't see today, either side do, is really plug and play the law that was read by the judge and what's being read to these jurors, what they have to consider. They're being asked to consider first-degree murder, second-degree murder, and involuntary manslaughter. Now, the judge is reading the instructions twice, and I think it would have been important if both sides really explain the law, because the Massachusetts law also recognizes something short of mental health affecting criminal responsibility. Mental health is read to them as a factor in determining the intent between the different levels of homicide here, the murder 2, and the involuntary manslaughter. What I really did like, John, which I thought Reddington did really well, listen, this guy's an old soul, an old warrior trial lawyer, been practicing for 51 years. You can see the passion in his argument. At one point in time, he turned to Lindsay and he referred to her as kid, and he's really done a good job of humanizing her. I think the prosecution did what they had to do, concede that she's suffering from a defect, but tried to argue that they have proved, I'm not so sure they did, that she understood the consequences of the action and that she could not stop what was happening because of that voice command.
Yeah, I think a lot of this is going to come down, and as you indicated with the defense attorney, the play to emotion here for the jury, not so much on the facts of the case. And it seems like maybe that's the prosecution's play as well, playing to the emotions of the jury and reminding everyone of the 3 lives that were lost here. We're going to play 2 clips for you. First one from the defense, and then the prosecution. We'll talk about them on the back end. Here is the defense.
How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got.
The prosecution.
Case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time.
And that's really what it comes down to. She wasn't diagnosed with the postpartum psychosis. It was something similar to that, but not quite it. Also some questions, initially they talked about all the drugs being taken at the same time. That was clarified by the prosecution. So again, I do think it's going to be hard for the jury to dismiss the fact that there were 3 innocent lives snuffed out here by the woman who admits to doing it in the courtroom.
John, there's nothing worse than having to defend someone that is accused of murdering children. And this case, like all cases, is won or lost in jury selection. People are not going to buy what you're selling if they're not predisposed to listen to this defense. Now, any juror that is on this defense had to say, because they would have been removed, that they can consider in a case where 3 children were murdered, a mental health and a not guilty by reason of criminal responsibility. What was interesting, John, in the clip that you showed, Reddington did a move that normally you would see the prosecution did. He humanized the family and he put up a picture of the victims and the family, but he's doing that also, he sensitizes the jurors to it, but to show that this woman, this wasn't planned, it wasn't premeditated, that Lindsay wanted help, wanted to be with her family, and wasn't getting the help that she needed. How much does it matter that the doctors failed her? Not so sure it matters so much, but last night I'm having dinner, I'm discussing this case with my grown daughter who's about to be a lawyer, and she says to me in the conversation, she's talking back to me about Reddington's talking points. And he has been very effective in that courtroom and on polls and in blogs I've read online, and really putting out there this woman and humanizing Lindsay. And that is really half the battle. It's an uphill battle, but I'll tell you this, John, of all the sanity cases I've watched or been a part of, this is one of the most masterful by an attorney, criminal defense attorney. I think the needle has been thread, but it's all down to 12 jurors, because 12 different jurors, different verdict. And he just needs 1 or 2. It's got to be unanimous. Someone to hold it up or to get this, to put the horse in the barn. He really just needs 1 or 2 jurors.
All right, so what are you going to be watching for once this eventually does go to the jury for deliberations? Are you anticipating a short deliberation period? I know these are difficult predictions to make. What do you think?
So I've learned long ago as a trial lawyer, right? You never know. I've seen short, I've seen long. Questions. If jurors have questions, those are windows into the souls of the jury because you can tell where they're going. I certainly think that they're not going to wrestle with whether or not she had the medical defect. I think both sides have conceded that. I think they're going to wrestle with does she not have the criminal responsibility? And if they find that she does, then they go to the different types of murder or manslaughter. They look at the premeditation levels and maybe determine, is this murder? Do they settle involuntary manslaughter? Which is a win, right? Because then there's no minimum mandatory. She's looking at anything from probation up to 20 years on each count for each child. But to me, to answer your question directly, I think it's a longer deliberation because there's a lot of gravity in that room. There are children that lost their lives here. And even though the defense has done a really good job, I would expect that there's a lot to talk about in that jury room.
Yeah, the judge here giving instructions to the jury. We're waiting for deliberations. We don't expect a verdict to come back today, but we will be watching very closely. Eric Schwartzreich, thank you so much for your analysis. Great to see you.
Great to see you, John. Thank you so much.